All right, let's go before this gets out of hand. Defendant Richard Allen verified motion to correct errors. Oh, hold on. I have to set that up there. Okay. Comes now. The defendant Richard Allen by counsel and files his verified motion to correct errors. For the reasons that follow, the court should either vacate Mr. Allen's convictions or set the matter set out below for hearing. Bombshell number 1. In violation of 6th and 14th Amendment, Mr. Allen was deprived of counsel at the safekeeping proceeding, November 3rd, 2022. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel. The court must presume Mr. Allen was prejudiced by being unrepresented during that proceeding. Yes, folks. That safekeeping proceeding that put Mr. Allen in prison instead of jail, Mr. Allen had an attorney. And they held that proceeding without his attorney. That, I didn't know that. I did not know that. That for me is, I mean, for me, personally, for me, that means everything happening after this is results of the rotten fruit kind of thing. If Carson Pratt, this was addressed during the trial, I think this was addressed outside of the jury's presence. Now when you say it, yeah. Transfers. This is the transfers for personal safety or safety of others. This was when the original judge. This was the only thing he did, and then he retired because he felt threatened. Where does the gin fund go? Jingles? Yeah, yeah, I presume so. And ow, Mr. This will be a stream with me drinking and saying ow, because Mr. Jingles is doing the boop with claws. Transfers for blah, blah, blah. Alleging that an inmate in a county jail awaiting trial is in danger of serious bodily harm or death or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger, blah, 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 blah. Yeah. I don't care. Whatever they claim. He had an attorney. The prosecution hid this from his attorney. It should be thrown out by this reason alone. By this reason alone, in my opinion. Mr. Allen was interrogated and arrested on October 26 and booked into the Carroll County Jail under a pseudonym. The next day, Mr. Allen's wife hired attorney Brett Gibson to represent Mr. Allen. In the evening of October 27th, Mr. Gibson sent a letter by email to the Carroll County Sheriff's Office and to Nicholas McLeland, the Carroll County prosecutor. What emerges from defendant's exhibit is the following. Sheriff Lathamby confirmed receipt of Mr. Gibson's letter by telephoning the evening of the October 27th. Also on October 27th, over the telephone, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Already there. See? The absolute fustercluck. Absolute fustercluck. This is insanity. Insanity, I say. Did I show this? I don't know. Thank you, Teresa. And thank you to Ignoring My Vices. Where does the gene fund go? Yeah, to Mr. Jingles. Nailing maps to the wall since 1969. Thank you. Did someone say map? I don't know. And thank you, Laura, for becoming a member. Welcome to the show. This is a commentary channel. I will interrupt with, I'm just being sidetracked. It is squirrel. Yeah, you know the bit. But again, look at this absolute fusterclock that is going on here. And this is the day of the arrest and the day after. Mr. Gibson then contacted Mr. McLeland by email, after which Mr. McLeland called Mr. Gibson on his cell phone. Again, this removes a paper trail, except that Mr. Gibson was smart enough to send the emails. Now, already here, Mr. McLeland, just by calling and not email back, tells me he was desperate in not having a paper trail. Oh, look at that. Thank you so much. When you come at the king, you best not miss. Test! Thank you for your $5 super chat. Thank you so much. We are heading in storm steps towards the goal. You guys are getting me. Oh, you are going to get me real drunk here. This will be a stream for the ages. And stacks, I can type now. Yay! Thank you. Mr. Gibson went to the Carroll County Jail where someone from the sheriff's office took Mr. Gibson to a meeting room. It appeared to Mr. Gibson the regular jail staff did not know Mr. Allen was there. Still on the evening of October 27th, Mr. Gibson finally met with Mr. Allen and advised him not to discuss his case over the telephone because calls would certainly be recorded. At about 10 p.m., Mr. Gibson called Mrs. Allen to say he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murder the next day. On October 28th, without Mr. Gibson present, even though Mr. McLeland and Sheriff Lazenby both knew Mr. Allen was represented, Mr. Allen was charged with 2 counts of murder and Judge Diener held Mr. Allen's initial hearing. Again! You don't do this in the United States of America. If you are being represented, he has to be there. If he's not there, the hearing is invalid, in my opinion. Hey, Dave is here. That's a gin. GD is in control of your math from now on. Yeah, my math will not math. Shortly after his initial hearing, Mr. Allen was whisked away from the Carroll County Jail to White County Jail without a safekeeping order authorizing the transfer. So, without telling his attorney, they had a hearing. And then they moved him in a clear attempt to make sure that Mr. Allen didn't get to see his lawyer. On November 1st, a letter from Mr. Allen was mailed to the White County Jail from the White County Jail to Carroll Circuit Court. In that letter, Mr. Allen requested that the court appoint counsel for him. Nothing in the letter indicated he was not already represented. Yeah, you can have representation. You can discover you can't afford it. You know you can't afford it, so now you ask for an appointed counsel. For some reason, although it had sufficient postage and was correctly addressed to the Carroll County Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to White County Jail. It was then remade from there as a show file in this court on November 9th, 2022. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the court as of November 1st. As a matter of law. It's not Dave? No, oh, it's not Dave. Dave has something else on his. Oh. The prison mailbox rule recognized by the United States Supreme Court provides that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities for forwarding to the court. Done. Over and done. Mr. Allen is represented, and now he's asking for somebody appointed to him to then take over for the person immediately representing him. The safekeeping proceeding was plainly illegal from start to finish. Yeah. First, Sheriff Lazenby transferred Mr. Allen to White County Jail with no safekeeping order in place. Next, Lazenby had no standing to make the safekeeping request on November 3rd due to the fact that Mr. Allen had been illegally transferred to the White County Jail. Once Mr. Allen was in White County Jail, the White County Sheriff was, quote-unquote, the sheriff statutorily authorized to make a safekeeping request under Indiana Code. Yeah, but this is Carroll County, where laws don't matter, where they don't care. They really, really don't care in Carroll County about laws. They are basically having a mix of communist and Sharia law applied in that county, in my opinion. Because Sheriff Lazenby had no standing to make the safekeeping request, Judge Diener had no jurisdiction to consider it. Second, Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue a safekeeping order at Lazenby's request. That is because Judge Diener had engaged in ex parte communications with Lazenby, helping Lazenby draft his safekeeping request. You all know this from the YSL trial. Ex parte meetings are always considered prejudicial and shall only be an extremely limited. But Judge Diener didn't care. So an illegal ex parte meeting. Have we heard that before? Yeah, we have. Rule 310 prohibits judges from drafting or reviewing documents except for family members. Judge Diener also violated Rule 2.9 of the code by engaging in substantive ex parte communication with Lazenby, which helping Lazenby draft the safekeeping ordinance certainly were. Having violated both Rules 310 and 2.9, Judge Diener was obligated under Rule 211 of the code to recuse himself and request appointment of a special judge before he issued a safekeeping order, not after, which is what he did on November 3rd. Yeah, so he did all of this illegal stuff, and then he decided to recuse himself, and now he's in retirement ever since. Good on you, Judge Diener, going to retirement with all that retirement funds and everything, patting yourself on the shoulder. You're a disgrace, Judge Diener. Absolute disgrace. Third, Sheriff Lazenby's November 3rd request by the Sheriff of Carroll County, Indiana, blah, 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 was not served on anyone. There is no certificate of service attached. Indiana Code that requires a safekeeping request to be made by motion. Indiana trial rules, this required that Sheriff Lazenby's motion for safekeeping order be served on the parties. Because Sheriff Lazenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for safekeeping order. Even if he claims Mr. Gibson was not representing Mr. Allen at the time, Sheriff Lazenby was required to then serve Mr. Allen personally. Fourth, Sheriff Lazenby's safekeeping request was not verified. I mean, how many laws and rules can you break at once? Ask Sheriff Lazenby and Judge Diener, because we are up to a dozen violations. Here, we are on page 6. There was therefore literally no evidence before Judge Diener from which he could make any factual finding required by Indiana Code that would authorize a safekeeping order. Fifth, Because a factual finding was required to authorize the safekeeping order, a hearing with notice to the parties on Sheriff Lazenby's safekeeping request was required. And we just reached the goal. It's like my grandmother used to say, may she rest in peace. Sometimes you eat the bar, and well, sometimes the gin, it eats you. All right, where's my gin? We hit the goal! Yay! Oh. And we will see how long it's and beaver shot glass. Oh. 10 Quarry London Dry Gin. Dun, dun, dun. 43%. Yep, that'll do the trick. Where were we? Yeah. 6. And perhaps most importantly, after all of this, a dozen violations of Indiana law, this is the most important. Mr. Allen had an absolute right to refuse being transferred to the custody of the department. Sheriff Lazenby's safekeeping request alleged no statutorily authorized basis for a safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for a safekeeping transfer is only a defendant's personal safety, a defendant may refuse the transfer. And they ignore that as well. Mr. Allen had no opportunity to exercise his right to refuse the transfer to the Indiana Department of Corrections custody or to make any of the objections set out above to the entire course of the proceeding. That is for a quite simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of the legal skullduggery that would land him in solitary confinement at the Westville Control Unit, Wabash Valley Correctional Facility, and Cass County Jail for 23 months pending trial. Because Mr. Allen had no notice of what was afoot, neither he nor his lawyer could make any arguments that would have necessarily prevented Mr. Allen's transfer. Finally, Mr. Allen's own absence from the safekeeping proceeding should be treated no differently from the absence of a lawyer to represent him. Yeah, they held this safekeeping hearing without Mr. Allen and without his attorney. Okay, if you don't have sound, refresh stream. Oh, I'm already a bad speller. Oh, this will be excellent. Yeah. One consequence of this should be that the Sixth Amendment and Article 1 of the Indiana Constitution should apply when a pro se litigant is excluded from a proceeding at which he or she has the right to be present and participate in. It is a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage of a criminal prosecution. The safekeeping proceeding, such as it was a critical stage at which Mr. Allen had a Sixth Amendment right to have his lawyer interpose all the objections to the November 3rd safekeeping order set out above. Because Mr. Allen was entirely unconstitutionally deprived of counsel at the safekeeping proceeding, the court must presume Mr. Allen was prejudiced by that deprivation of counsel. Oh, we need a new goal. Start another goal. Yep. There we go. Alternatively, of the Indiana Constitution provides in part, in all criminal prosecutions, the accused shall, not may, shall have the right to be heard by himself and counsel. Section this affords citizens ever greater protection than its federal counterpart. Not only does 13A guarantee a criminal defendant the right to counsel at any critical stage of the prosecution, but, quote, the rights afforded under Section 13 also attach prior to the filings of formal charges against the defendant. Oh, here's a footnote. The court need not speculate whether safekeeping proceedings have serious consequences for an accused. In addition to being moved hours away from his lawyers for over 23 months, Mr. Alley was unconstitutionally kept in solitary confinement in an Indiana Department of Corrections prison and was shackled, leashed, and hooded and deprived of human contact. As a consequence of that torture, Mr. Allen became psychotic. Short of his death, it is hard to imagine more serious consequences for Mr. Allen flowing from the November 3rd safekeeping proceeding. And for you jackasses out there that says, oh, this is a prison, jail, it's not a vacation, I have an open challenge. You sign my waiver where you allow me to put you through this for a week. And we'll see what I can make you confess to. Okay? Haldol, people screaming at you. Guards that hates you. Will you sign that waiver? Unless no, then shut the fuck up. No, don't. Please continue to prove to the world that you are a bloodthirsty sociopath who likes to know about torture. Yeah. Or sign that waiver. Try to prove me wrong. Try to make it a challenge. It's not like I have military training from the Cold War days. Let's get back to this. Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping proceeding. This should be partially disturbing because had he been given the opportunity to do so, Mr. Absent had an absolute personal right to refuse the transfer to the department's custody. In either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. Who here believes Judge Gull wants a hearing about this? She will deny it. I'm quite sure of it. I'm quite sure. And thank you, Brandon. Been there, done that. I rather hand out with the starving genius. Yep. And then here, in violation of due process clause of 14th Amendment and its progeny, sorry, the state presented the testimony of Brad Weber. That Mr. Weber, yeah, this is next part that they want in as a correction of error. Oh, this is fun. This is fun. Oh, I'm going to have words about Mr. Brad Weber. Then Mr. Weber arrived home in his white van about 2:30 p.m. on February 13, 2017, either knowing that the testimony was false before it was elicited or failing to correct it once it had been elicited. Folks, prior to this Brad Weber thing, I said that Brad Weber was either lying in 2017 or he was lying in the trial. As it turns out, he was lying both times. A lying liar who lies. And remember, According to that one juror interview, this van was what got Richard Allen convicted. And as it turns out, this van was a lie. Complete lie from start to finish. We will get to it more in detail. A conviction obtained through use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it happens. At trial, the undisputed evidence was that LG's Libby cellular telephone stopped moving at 2:18 p.m. for 7 minutes until 2:25 p.m. It then started moving again and stopped moving permanently at 2:32 p.m. In closing argument, Mr. McLeland called it a hard fact that LG's phone stopped moving at 2:32 p.m. Oh. You forgot to add those super stickers to your gym tab, and they were in Kingston. What? Oh yeah. Okay. We are. You see, we are 2 towards the goal. We are actually 4 towards the goal with the super stickers. Thank you for reminding me, Brandon. Thank you. And thank you again for your super chat. The state introduced an alleged confession by Mr. Allen by Dr. Monica Walla, a psychologist. You all know she's been fired since because misconduct. Yeah, that's the test. I remind you, the testimony of Dr. Monica Walla. She was fired for misconduct. And besides, there is so much more about Dr. Walla. I have to make a separate video of sorts just with the absolute unethical behavior of this Dr. Walla. Yeah, because there's too much to fit, because I need to get through this. But let's just say, okay, let's say this. In my personal opinion, everything in in Richard Allen's confessions was fed to him by Dr. Walla. That is my opinion, and I will stick to it. If she wants to sue me, go right ahead. I would love to get to Discovery, to get all your phones, all your computers, all your messaging. I would love for that to be public. You absolute twat. Psychologist contracted by the Indiana Department of Corrections to treat inmates at Westville Correctional Facility. In this alleged confession, Dr. Wallace, she shredded her notes. Cunt. If you don't like curse words, this is not the stream for you. There will be words. And now you all have provided the funding for me to ignore the fact it will probably be demonetized. In this alleged confession, Dr. Wallace stated Mr. Allen said he had abducted LG and Libby and Abby on the south side of the Mononhigh High Bridge and forced them down the hill on the south side of Deer Creek. Dr. Wallace said Mr. Allen said that he was on the south side of Deer Creek and was planning on essaying them when he was interrupted by a van. Dr. Wallace said Mr. Allen said he became scared when he saw the van and crossed Deer Creek from south to north from the Weber property to Ron Logan's property, taking Libby and Abby with him. The state also introduced the testimony of Brad Weber, the fucktwat, that he left work on the Subaru factory in Lafayette, Indiana at 2:02 p.m. and arrived home in his white cargo van at about 2:30 p.m. Yeah. Oh, the state argued Mr. Webber's arrival home in its van was what interrupted Mr. Allen, causing him to take Libby and Abby across Deer Creek to end them on Ron Logan's property. The arrival of Mr. Webber's van at about 2:30 was, quote-unquote, a detail only the killer would know, said the state. But the problem is that the state also contended that Libby and Abby died near in time to 2:32 p.m. when Apple Health data from Libby's phone showed that the phone stopped moving. If the arrival of Mr. Webber in his van interrupted Mr. Allen, forcing him across the creek, Mr. Webber would have had to arrive near his parents' house at the end of the private drive before 2:32 p.m. Then, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Webber could not have arrived anywhere on the private drive before 2:44:54, more or less 2:45. His arrival at about 2:30 could not have been a detail only the killer would know, because it did not happen. Never happened. Mr. Allen was convicted on a deliberate lie by Mr. Webber. The state knew, or should have known as much, as the state either elicited Mr. Webber's testimony about the time he arrived home, knowing it was false ahead of time, or failed to correct that testimony once it had been elicited. Defendant's Exhibit 3A, as attested to by Matthew Hoffman in Defendant's Exhibit 3, is a video recording made on February 13th, 2017 by a security camera that was in the house at this address. The video recording was provided to the defense by the state and is therefore being in the state's possession, meaning the state knew Webber was lying. Sorry for yelling. I'm angry. Rachel says, isn't that prosecutorial misconduct? Yes, it is. I absolutely agree. Blah, 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 blah. Based on the date and timestamps on the video, it appears that the security camera was set to record date and time information as part of the recording. The time of the security camera was set 12 hours behind, such as 12 a.m. is really 12 p.m. on the same day. This is apparent due to the daylight and moonlight on the video and the associated timestamps. The security camera had a wide-angle lens that captured video of traffic on that road at the beginning of the private drive to the Webber property. According to the time and date stamps on the security camera recording, shows a white vehicle going north, entering the frame at approximately 2:44:33 p.m. on February 13th. Also shows a white vehicle continuing into the private drive on the Webber property at approximately 2:44:54. It's viewable on YouTube at the following address. Oh, look at that. Elena Stansby for 10 pounds. Wow, that's thank you. The voice matching evidence was the biggest load of rubbish as well. Yeah. Oh, I've been talking about that on several streams. That whoever cop it was, I don't remember his name, even was allowed to say, I recognize this as Richard Allen's voice. I say that cop lied, and he knew he lied. Why do I say that? Because the voice on the recording is enhanced, meaning background noise gone. Certain things enhanced to make it more clear, meaning it wasn't the actual voice. So if you claim you recognize that voice, it's an altered voice. Altered. So anyone claiming recognizing anything from that recorded voice, enhanced voice, you're either a moron, stupid, or you know you're lying. In my opinion, I have to add that. No, I don't have to. I really don't, but I do it anyway. Exhibit is a video file that contains 3 Zoom clips from the video recording at this. And yeah, that video shows clearly Mr. Weber was lying through his tooth. I assume he only has a few teeth. Because I don't know why. I'm just assuming. There are 3 stills, blah, blah, blah. Yeah, everything about, yeah. Here it is, the picture. In the video, you see it passing by. A full, at least 13 minutes after Mr. Weber said he was there. Completely ruining the prosecution's timeline. Completely. Other video files produced by the security camera provide the defense in discovery and covering the time from 2 p.m. to 4 p.m. on February 13th do not show any other van driving north. So only one vehicle resembling a white van between 2 and 4 p.m. So all of that is about the van and the recording, and we know now Mr. Weber lied. He lied back in 2017. He lied under oath in court. Why? Because in 2017 he knew he would be a suspect, so he lied about being at the crime scene. He said he was checking ATMs, and they believed him without checking if he ever actually were at the ATMs. They actually believed him, and just okay, on face value. And then in 2017 he lied again under oath. So he's a lying liar who lies. I've seen this on X that, you go there and try to do blah, blah, blah. I already been to Delphi, Indiana, you fuckwats. I have a whole stream about me and Mo walking around in Delphi, Indiana. I stayed, after Mo went home, I stayed in Delphi, Indiana for hours. Not one person approached me. Not one. Why? Don't know. Don't care. But for anybody, you should go there. I've already been there. And if I ever were to go back, I wouldn't forewarn anyone. I would just show up. And those diaper Nazis and inbred motherfuckers would probably not approach me again. Thank you, Brandon. I'm declaring this. You scared, white boy? Thank you. Thank you. Yeah, this stream is already demonetized, so yeah. Thank you for the monetary support, because there ain't going to be no ad revenue from this one. And no, I do not have midstream ads on my streams, on my live streams. I have ads on my videos. After this stream has concluded, I might put in an ad every 30 minutes, but you guys who are here live will not see ads. Okay? Let's get back to this. To obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony about the time he arrived home and used that testimony to corroborate Dr. Wallace's rendition of Mr. Allen's statement that he became scared after he saw a van, so he took the girls to the north side and ended them. This was the only statement allegedly made by Mr. Allen that contained any detail that might be true. The state therefore cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have, quote-unquote, an effect on the outcome of the trial. Yeah, because the one juror who have come forward said explicitly it was the mention of the van. Now, that juror, being an absolute moron, besides the point, that's the jury system. You get morons on jurors. It's the bus stop people, an average of the average American, which means you can have people smarter than the average, and you can have this juror who barely knows how to breathe, in my opinion. Alternatively, where the court defined that the state did not know or should not necessarily have known about Exhibit 3A, then both exhibits constitute newly discovered evidence that would probably produce a different result at a new trial. Accordingly, for either reason, the court should either vacate Mr. Allen's conviction or set this motion for a hearing. And we all know Judge Gull will deny a hearing. She will just deny it without a hearing. But this, what they are doing here, is clever, because they are putting it on the record for appellate reasons. Now, sadly, even an expedited appeal is at least 2 years away. That's the sad truth of it. All right, let's go to the next one here. Ron Logan's confession to Ricky Davis before May 15th, 2017 is newly discovered evidence entitling Mr. Allen to a new trial. Yeah, folks, there are more evidence against Ron Logan in that one confession than the entirety of the case against Richard Allen. The entirety. And they ignored it. Oh, and I have some things that might not be apparent, but will explain why this was ignored. If I'm not too drunk to say it by then. Thank you, Nailing Maps to the Wall since 1969. I hereby declare this gold donation number 10 by decree of mathematics. Did you just say Ricky Bobby? What? Wait, what? Who's Ricky Bobby? I have no idea. Okay. Let me just check here. How many? I have one. I have 2 super stickers. So we are two from. We are still 2 from. But just in case, to be certain, just keep it going. Thank you so much, guys. Thank you so much. I really, really appreciate the monetary support you supply. I really, really appreciate it. And it will help me get into Utah in September and to Miami. Ricky Bobby is the lead character in the movie Talladega Nights. Okay. Not seen that one. Remember, I'm not American. I'm not American. All right. Dr. Kaur was the forensic pathologist who conducted the autopsies. His original opinion held for years about how they died was 2 weapons were used. One serrated blade and other a straight edge blade. For the first time at trial, having a eureka moment at his tool bench, Dr. Kaur opined that the girls could have been ended by a single box cutter rather than 2 different knives. Yeah. And thank you, Snacks. Near there. Yeah, we are near there. Near there. That box cutter is really important. Remember that box cutter thing, because this is something only the killer would know. Defendant's Exhibit 4A, as attested to by Matthew Hoffman in Defendant's Exhibit 4, is a redacted copy of a tip from the Orion database of tips dated May 15, 2017. In that tip, which the state has always had, Ron Logan is alleged to have confessed to Ricky Davis sometime before May 15th, while they were in prison together, that he had killed Libby and Abby. The material part of Ron Logan's confession to Ricky Davis, as it appears, is produced below. Logan confessed to Ricky step by step of killing the two girls. Logan told Ricky how he burned his clothes in a fire pit and where it was located, used box cutters, and struggled with one of the girls, and thought drops of blood from his nose ended up on her clothes. Ricky also advised that he killed the older girl first. And here is a footnote. Regarding Mr. Allen's supposed confession. He also said he shot the girls in the back and buried them in a shallow grave. Neither of the girls were shot in the back, and neither was buried in a shallow grave. Nailing maps to the wall. Thank you for your $10. Challenge. We have a flag on the field. Accountant Gigi. Foul on the play. The goal is teal, as in $5 or higher. So it is not the amount. It is the total amount of dough. It's the number of supers. But yeah, okay. Darn it. Why did I agree to have Gigi as... All right, here we go. Apparently, we're on next shot. And I'm using gin. Thank you, Alan, for being here. Cheers. Still using beavers. The beaver shot glass because... And this is something I have over here. Where is it? Darn it, where are you? I have my beaver shot glass and I have my jug because I like beavers and jugs. Cheers. Oh. Oh, wow. All right, let's continue here. Yeah. When people claim, oh, he confessed 60 times. Yeah, he also confessed to killing his mother while on the phone with his mother. He also confessed to starting World War III and the murder of a matchstick. Yeah, so... Ron Logan's confession to Ricky Davis, as reflected in the tip on the Orion database, and made a mere 3 months after the girls were killed, were detailed. Law enforcement followed up on the tip, as attested to by Matthew Hoffman, accurately reproduces the handwritten notes taken by Indiana State Police First Sergeant P. Hansard about his interview with Ricky Davis at the Newcastle Correctional Facility regarding Ron Logan's confession to Ricky Davis. Those handwritten notes of First Sergeant Hansard are attached to Indiana State Police Detective Wolf's lead narrative summary cover sheet, as it was provided to the defense in discovery. First Sergeant Hansard notes of his interview with Ricky Davis about Ron Logan's confession provide even more detail. And folks, this is not the only time Ron Logan allegedly confessed to another person. There's one more out there. So, 2 confessions with details that actually, back in 2017, nobody knew about. Iron Rabbit, member for 16 whole months, just up to hit the thumbs up. Now back to RL. And she gifted 5 memberships. Oh, I need to have a banner up. Hold on. I have no idea who is in the lead, but we have 5 new members. 5. There. No, wrong one. There. I have no idea who's in the lead between. I would assume it is Let's Go Brandon for the honor. I will just put down. Hold on. Honorary Viking. Let's go Brandon. As of now, I have no clue about the amount of thing. Yeah. John Schön, member for 4 months. I sent you a Twitter DM. Interview with Logan's girlfriend. Yes. If we get to it, Logan's then girlfriend, who he assaulted and almost murdered, her interview is out there. And all of a sudden, that one makes a lot more sense. And thank you so much, John Schön, for being a member for 4 months. Thank you so much. If any of you are considering being a member, $3 a month on YouTube. And you get members-only content and stuff like that. Oh, folks, for you who have been with my channel for more than a year, you know about Hugo, don't you? Hugo the ass burner. He was behind me for the first year. Let me present to you Hugo 2.0 from the seeds of Hugo the ass burner, because Hugo, he survived 2 years. 2 years as a plant. Not this year. So I planted some of the Hugo the ass burner seeds, and now we are going to get to see him grow up right back there again. Yay! Okay, let's get back to trying. No, the case, this thing. First, Sergeant Hansen notes of his interview about Ron Logan's confession provide even more detail. Hard as they are to decipher and subject to debate and correction, those notes reveal the following about Ron Logan's confession to Ricky Davis. It seems to say, talking about knowing one of their dads. To walk with them. One of them wanted to turn around. Grabbed youngest shoulder. It's okay. Oldest freaked out. One said something about calling police. SA wasn't true. Originally not trying to do that to them. Paranoid about probation. Felt like he crossed line when he grabbed the youngest one. Which corroborates the walking around thing on the phone. He started talking. Ironic, should have been in school. Knew one of their mom's waitress at a bar. Here's the thing. Rick Allen knew nothing about these girls. Ron Logan, on the other hand, seems to know both the girls, one of the girls' moms, and one of the girls' dads in detail. Something Richard Allen had no knowledge about. Brandon, can I say railgin? Which word is they aren't located? I have no idea what that means. Thank you so much again for your $5 super chat. Yes, super chat censorship running wild today. Yeah, YouTube has gone overboard, in my opinion. Hello, Slidey Pie over at Rumble. Yes, I am streaming this over at Rumble as well. You can find me there as Big Nick Starow on Rumble. And I'm also streaming to X. So if you're an X, get over here instead, because this actually pays me. X doesn't. Animals walked with them, willing to go check out horses. He told them he had rabbits in barn, walked through trail in woods. Oldest paranoid, didn't want to go. Youngest wanted to see horses. Ron at the time was in his early 60s or late 50s, I think. Eric Skade asks. I think chat will correct me if I'm wrong. Seems to say oldest turned to help youngest. Oldest started looking, kicking. Youngest seemed. He now grabbed oldest. He said he got hit on nose. Scared he got blood on one of the girls. We already know there is unknown male DNA on the girls. We already know that. Unknown. According to the prosecution, the amount is too small to test without destroying. I call BS on that. It might be too small for this local little crime lab. I do not believe it is too small for an actual outside crime lab. But why do I say that? Well, because I have covered the Gilgo Beach serial killer case, and they actually could extract full DNA profiles from hair that had been buried underground for 10 years. That's the level that specific crime lab is at. It's a private crime lab. So if they wanted in Carroll County, they could easily send it to that crime lab without destroying the evidence, without destroying the sample. They just don't want to, in my opinion. Pulled box cutter. Here it is, box cutter. Something only the actual killer would have known back in 2017. Slit oldest one, hit an artery. Youngest scared, took little girl with him for a while, never said where. He said he cut her to cut both necks. He left again, came back later in the evening. Search going on. And we know through cell phone data that Ron Logan was outside of his house roughly, and he got a text 20 minutes before the supposed about the contention about the phone, that headphones was plugged in and then plugged out at 10:30 something p.m. Well, he received a text at 10:00 something at the evening outside of his premise, outside of his home. Place where four-wheelers go. Burn his clothes in burn pile, hiking, boots, gloves, bag. Later I was trying to move oldest one to area not going to be found. Source of boots be in burn pile. Next morning, two other girls knocked on door, asked to search on property. Feel weird if he said no. He let them take off, got a hold of family member and got out of area. Yeah, remember also, he lied about his alibi. Ron Logan. He lied about his alibi. Ron Logan was 77 at the time. Let's just... Back in the day, Lois Gibson, certified forensic artist, made this in April 20th, 2017. Let me just show it. Hold on. She got a picture from the video of Bridge Guy, and then known person B. Above left to right is the image of known person B. Laid atop an image of suspect A in varying degrees of transparency. So here, over here on the left side is Bridge Guy. Here on the right side is a full image of Ron Logan. It is impossible to do a perfect comparison between persons in different photos due to variances in the angle of the lens, lighting, pose, time of photo, and other variables. However, when known person B's image is laid atop of suspect A's image in varying degrees of transparency, it seems to point out considerable similarities. If known person B was geographically near to the incident described in Carroll County Sheriff's case number this, the similarities shown by the above photo comparisons seem to indicate a possibility that they are one and the same person. Ron Logan, by the way, was 5'10". With no defensive. Yeah, we all know, according to what the state presented at trial, they claimed that the girls had no defensive wounds, which somewhat contradicts Ron Logan's confession. But then it would have been easily disputed at trial. But this was never even allowed in. Yeah, Elena. Richard Allen is under 5'5". And every witness who claimed they saw Bridge Guy or a man near the bridge at the time described either a tall person, taller than them, at 5'8". Not one described a short person. Not one. Even in trial, the prosecution didn't ask any of the witnesses to say, is the person you saw that day here in this courtroom? Not one of them. Because they were scared of the answer. And before you say, well, the defense didn't either, the defense has no obligations. The 100% burden of proof is on the prosecution. Okay, let's get back to reading from the thing. And it seems to say, first time he's seen them from property, home, etc., guns, etc. During struggle, youngest girl, not. Happened to friend to stand there, head, neck, artery. Defendant's Exhibit 4C is a handwritten note signed by Ricky Davis dated June 21st, 2017. The same day First Sergeant Hansard interviewed him. That handwritten note is attached to the same lead narrative summary cover sheet as is contained in the same file as First Sergeant Hansard's handwritten notes that are Exhibit 4. B. Ricky Davis' handwritten note about Ron Logan's confession to him says, Mr. Logan has made reference to killings in Delphi, Indiana. He told me he was He was the one who had killed those girls, that it got out of hand. He walked with them in the woods to his property, and the girls wanted to turn back. Said something about walking the blah, blah, blah. He grabbed the youngest girl to reassure her it was okay. However, they panicked, and he also panicked. He indicated he ended up cutting the oldest with a box cutter. He went on telling me that he killed both of them because it was took too far. So in addition to the other details that fit the known facts, Ron Logan confessed to Ricky Davis that he used box cutters to kill the girls. If instead of for the first time at Mr. Allen's trial, Dr. Kaur said 7 years earlier, said the girls could have been killed by a box cutter, there would certainly have been probable cause to arrest and charge Ron Logan with the girls' murders. As it was, the FBI 2 months before Ron Logan's confession to Ricky Davis, had obtained a judicial finding of probable cause to search Ron Logan's property. You would assume that would be enough nexus to allow Judge Gull to allow a third-party defense. She didn't, because she's a cunt. Welcome to my show. I use cursive words. Under the circumstances, Dr. Core's trial testimony about the box cutter possibly being used to murder the girls makes Ron Logan's confession to Ricky Davis newly discovered evidence that would either be admissible through Ricky Davis or through First Sergeant Hanson under the due process clause. Ron Logan's confession exculpates Mr. Allen and would probably produce a different result at the retrial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. We all know Judge Gull will deny this without a hearing. Next one. Defendant's Exhibit 5. The affidavit of Stacey Eldridge states that dirt or water damage to the phone could not have been caused the auxiliary jack on Eldridge's phone to log wired headphone plugged in and wired headphones unplugged. Miss Eldridge's expert opinion is newly discovered evidence that would probably produce a different result at a new trial. Hey, Brandon. If you're not first, you're last to get skewed with a box cutter, Ricky Bobby. I need to watch that movie. What was it? Talladega Nights? I have no idea what that is. I'm not American. And now officially we are goal achieved. Start another goal. Huh? All right, no new goal up. We are 2 or 3 ahead of it already, I think. I don't know. GD is the official counter. I don't do math. Normally, I'm even worse when I do this. Yeah, so this, at trial, the defense had an expert say about the plug in and plug out of something through the headphone slot in her iPhone. Then, apparently, the state had one of their officers go outside and Google it during a break and came back to testify. It's absolutely horrendously stupid that was even allowed. But it was allowed in because Judge Gull is a cunt. So all of that, I've been through that part already. Conclusion: for the foregoing reasons, Mr. Allen respectfully requests that the court either vacate his conviction or set the matter suitable for hearing, and for all other just and proper relief in the premises. So this is by Andrew Baldwin, Jennifer Auger, and Bradley Rossi. This is probably the final thing they could do for Mr. Allen as their actual defense attorneys. Now, from now on, it is his appellate attorneys that has the power. Unless, by some odd reason, Judge Gull decides to hold a hearing or vacate the conviction, which I don't believe she will.